employment topics for a variety of professional organizations in Kentucky. She also conducts training for managers, supervisors, and the general workforce, and provides labor and employment compliance counseling. Currently, she serves on the board of directors for Commerce Lexington, the Continuing Legal Education Commission of the KBA, and the board of directors for Legal Aid of the Blue Cross. Last but certainly not least is Professor Scott Bauries, who is the Associate Dean of Research and Wilbert D. Ham Professor of Law at the UK Rosenberg College of Law. Professor Bauries joined the UK law faculty as an assistant professor in 2008 after working as an associate with McGuire Woods, where he practiced labor and employment law, higher education law, and complex commercial litigation. Professor Bauries graduated first in his law school class at the University of Florida, where he was the senior galleys editor of the Florida Law Review. Immediately after law school, Professor Bauries clerked for the Honorable Emmett Ripley Cox of the United States Court of Appeals for the 11th Circuit. While attending law school, Professor Bauries pursued a PhD in educational leadership and policy and taught undergraduates in the University of Florida College of Education. In 2009, he successfully defended his doctoral dissertation, Judicial Review and the Separation of Powers in State Constitutional Litigation, challenging the adequacy of education spending, complementary analyses, and proposed a model. Based on this work, the Education Law Association selected him as a recipient of the Joseph C. Beckham Dissertation of the Year Award for 2009. Prior to entering legal studies, Professor Bauries taught English and coached soccer for several years at the secondary school level in Central Florida. He also served as a school district grant funds administrator and curriculum staff developer. Currently, he teaches civil procedure, employment law, state constitutional law, advanced torts, and education law. His professional and academic interests include judicial decision-making, federal and state constitutional law, employment law, and education law. Thank you all so much for our discussion today. Is there anything you'd like to add before we jump into our discussion?
Just want to congratulate you on getting that dissertation title out without stumbling. Tell you what,
I did practice.
I still can't do it myself.
Okay. Well, everyone, as you can see in the handout that's been provided, we're going to break down our discussion today along the lines of kind of the work life cycle of a diverse employee. So we're going to start with hiring diverse employees, move on to retaining diverse employees, and then ending with the discussion of discrimination claims. So let's start at the very beginning. Panelists, why do you think it is important for employers to hire diverse employees? What do you think are the major barriers that are preventing the hiring of diverse candidates?
So I'll go ahead and get it started. What we know with respect to hiring diverse employees is that there is a long history, right, in this framework. And so when we think of diversity and diversity management and the evolution of it, we know at the outset, diversity management really focused on providing access to racial and ethnic minorities, to women, and other historically underrepresented groups. There, the objective again was access. Part of where we're challenged is not just in terms of providing access, but providing meaningful opportunity in their unique being. So we see the shift from just having diversity to having diversity and inclusion, because inclusion really speaks more towards having individuals to show up as their authentic self, bringing their diversity of thought, bringing their uniqueness, and having that to be acceptable, and not only acceptable, but encouraged, so that they can make meaningful contributions in the workplace. What we know is that the McKinsey Institute has conducted several studies about the value of diversity and inclusion. Right? So adding that second component. And each of those studies has demonstrated statistical significance with respect to diverse and inclusive workplaces outperforming non-diverse workplaces. And this concept is known as diversity innovation. And so I've given you the long way to answer the question is, while we may have started with some moral or ethical obligation, which is still critically important in terms of providing access and inclusion, we're now at the place where there is a sound business case for why diversity matters to employers, and it's because it affects their bottom line. The greater the diversity, the greater the inclusion, results in greater output and greater profitability. So that message has been received. There is a lot of information out in discussions about belongingness, right? And what we know about belongingness is that's not a new concept. So even when there was access, there was belongingness. It was just the method of belonging. So historically, racial and ethnic minorities in particular, their belongingness was predicated on assimilating, conforming to existing standards to make majority groups feel comfortable with their presence. Assimilation, conformity, groupthink does not result in innovation. In fact, it just the opposite. It diminishes innovation. And so now we see the drive again towards inclusion, which is intended to maximize. And so for prudent employers who have picked up on the value and the benefit to profitability, there is a greater sense of inclusivity. And that's where a lot of the focus is. What are the barriers to hiring diverse employees? They're the barriers that existed pre-1964. Part of that is explicit bias, explicit discrimination, right? And then there is a growing sense of implicit bias, the unconscious level of bias, predicated on how we've been socialized. So that's even for well-intentioned individuals. There might be some tendencies, cognitive processes that draw them either to affinity bias because we like sameness, which again, sameness does not promote innovation. It replicates what we already know, or confirmation bias, that we have some built-in mechanisms about who we think might be the most qualified candidate. So those are structural issues in nature. And so what I say is there is some level of individual agency where there may be someone who is making the hiring decision who engages in explicit or implicit bias. But the other thing we have to consider in this space is that the structure itself has inherited the bias because humans develop the structure. So we're talking about structures, policies, practices, procedures, right? And so those are the challenges. It is individual agency, structure, culture, right? And just a history. And so the way out, and I don't think this is part of this question, but we'll talk about this later, is really getting into some more equity-based models. But that is sort of the baseline foundation. The other thing I probably should have said before I started down this path is, in the interest of full disclosure, in light of the current fight for racial justice and the Great Awakening, I'm going to attempt to answer or provide responses framed within that context for purposes of our conversation. And so that's part of our challenges with hiring. The other thing we know about hiring now is that there's a lot of use of artificial intelligence, right? Because it eases the cost of going through the hiring process. What we know, however, is that in that space, there is again inherited bias because machines learn through training data. The training data is based on how humans made decisions historically, and what we know through a series of certain incidents, including Amazon, by way of example, is that the machine picked up on biases that were present in humans. So the machines are starting to illuminate some of those implicit biases that we could not see historically. And so that's another area that we need to be profoundly focused on. And the challenge in the space of artificial intelligence is that oftentimes the process that is in between the input, which is the training data, and the output, the actual decisions, is inside of something we call a black box, which means we have no idea what the nexus was for how it reached the decision, which is critically important under Title VII, right? What was the predicate for the decision making? And so we have a myriad of challenges ahead that if we're not proactive in addressing them for where we are as a contemporary society, not where we were in 1964, but what does identity look like in 2020 and forward? And how does hiring work 2024 and how do structures work. And so we're sort of in a period through this awakening of where there's been a great illumination of structural issues that I think need to be addressed.
LaToi or Professor Bauries, would you like to chime in?
Go ahead,
Well, I
LaToi.
think Tammy, go ahead.
Go,
Professor.
please go ahead.
I was just going to say, I think Tammy hit it right on the head, and I hate to even follow up with that because I think she identified all the important factors and considerations at play here. I think, you know, I'm so happy to hear her say at the onset, you know, the distinction between diversity and inclusion. You know, put another way, diversity is just the mix. Inclusion is making the mix work. You know, and so when we think about where we are today, our employers, our clients, our neighbors, and just anyone that we typically interact with, they understand that diversity is necessary. And what we understand going forward is inclusion. When you include, you bring together unique ideas that are truly valued, listened to, and engaged, and people are given every opportunity to thrive within respective organizations. You have higher employee engagement, reduced employee turnover, better company representation, both publicly and privately, and then more importantly, a variety of different perspectives to bring to the table to come about, to approach issues and bring upon resolution. Just results in better decision making. So that's why hiring a diverse workforce is important. With respect to the barriers, I think Tammy hit it on the nail. You know, beyond those systematic barriers that we have to really strategically identify and work towards with an intentional plan of developing resolutions or thinking outside the box to come up with different models that recognizes our diverse and unique workforce and capitalizes on those opportunities for these individuals to thrive, go beyond those systematic change. I mean, they go as hard as just family influences, peer influences. You know, I don't know if Tammy, if you experienced this, but being a first generation law student within my family, just the amount of negativity somewhat that I had, or you can't do that, no one could do that, or the perception from others that this young Black individual cannot succeed was a barrier. I mean, I even remember discussions among the Career Center. You know, you have the best intentions in mind, you're getting guidance from people who have been out in the workforce, know how it is within the legal perspective, and you hear them say, oh, are you going to straighten your hair or wear it natural? You know, those types of things can plant biases, whether unconscious or intentional, and create additional barriers. I won't call them barriers because barriers are, to me, are things that you can't overcome. To me, challenges as it relates to hiring a diverse and inclusive group.
Well, it's clear that I'm definitely not the expert on this panel, but I'm not sure that I can add much to what's already been said here. So maybe I'll just focus on my particular area of academia and maybe try to add something as to why diversity is important in academic hiring. And I perceive as academic hiring as being directed toward creating a workforce that will create the future force of leaders in our society. Lawyers are among those, but there's lots of other professions that falls into as well. And we believe that in academic hiring, diversity is very important because of both the collegial nature of academic governance, the fact that everybody has a voice, and so that the challenges that LaToi spoke of are lower there once someone is on the faculty because they have an equal voice to everybody else and they don't have to necessarily prove themselves or become part of a dominant culture in order to be able to speak on governance matters. So there's a unique opportunity there to bring a sort of exponential benefit through diversity-based hiring. Essentially, diversity becomes inclusion almost automatically just because of the nature of the way that academic governance is conducted. But also mentorship. Mentorship flows down to the student body and it assists us with probably one of the biggest structural barriers to diverse hiring in academia, and that is the sort of what we call the pipeline problem, the idea that there's enough structural discrimination in the system that not enough candidates are filtering up into academia such that each academic institution can reliably produce a diverse workforce without a lot of effort and a lot of expense. And that's a problem that goes down to the structural elements of society that go all the way back to housing discrimination, which we'll be talking about in the next section, that filters into school discrimination, which is part of my main work, and that filters up into the higher education system. So the remedy that can come from our end in diverse hiring is building a network of mentors for other people of color who are coming up through the system and can show them that system is a place where they belong too. So we see that as an instrumental value for our own purposes. But I see that as connecting up with the societal issues, because what we're doing is training leaders that will go out into society. And the more leaders of color that get trained, the more they will be in higher positions, like leading law firms and being partners and things like that. And the better that these goals of inclusion can be pursued.
And that leads directly into the next question, which is kind of turning from the general discussion to specifically about our own field and law firms in the legal field. Numerous articles have been published regarding the specific issue in our field about hiring diverse candidates. And picking up on what Tammy was saying, that the research shows that a more diverse and inclusive workforce is a more profitable workforce. I was wondering if you could speak to why you each think that this is such a major issue in our field specifically, both with regard to hiring diverse candidates and then the inclusion factor that all of you spoke of. Tammy, if we want to go back to you.
Sure, why not? I'll start with this notion that there are a litany of unchallenged structural assumptions within the legal profession, starting with admission to law school, right? So we use, quote unquote, the standardized test approach, right? Which to me already signals there's going to be issues. It's premised on whose standards. So there is a challenge. And we know that standardized testing has demonstrated implicit biases or explicit biases, but that they are not necessarily predictive of actual ability to succeed or perform in law school. So we're already challenged by who's going to gain access in the first instance, predicated on a test score. Secondly, once we are in law school, questions emerge about additional unchallenged assumptions. What are we really measuring in law school? Are we measuring based on evaluation from law school professors, many of whom have only had limited access, if any, as actual practitioners, and have spent most of their careers as professors, right? So are we measuring or assessing and evaluating who will make a good law school professor versus who will make a great practitioner? And so law firms, but big law in particular, they tend to focus heavily on GPA and whether or not individuals are on law review. Those may be strong predictors of who will be a great college professor, but that does not necessarily translate into who will make a great lawyer. And so what we tend to do by basis of how we're evaluating admission into law school and then admission, if we're focused on big law, is we create, again, groupthink. We have affinity bias. And having been on both sides, both in private practice as in-house counsel, oftentimes the things that we evaluate as positives in law school were particularly draining on me as an in-house counsel. So when I need information about a specific issue, a case, a question about legal compliance, I don't necessarily want a law review article because we're inundated. I need someone who has great business acumen and understands how my business functions and can provide me with an accurate business response, not just a legal response, right? Those are two different things. And so there is great deviation in terms of what we're assessing and what the actual needs are. And so we end up replicating this mirror image. And so the mirror image tends to be, when you look at a law firm governance, it's male dominant, primarily white men, some men of color, women, white women, very few, if any, women of color. So we are in essence making assumptions, which is part of implicit bias, about who gains access due to the way in which law firms work. Most of them apply a core VAF model, I believe. I'm not an expert in that space, but you have the partnership and the associates. And partners tend to have the ability to assign work based on their personal preferences. So who gets developed? Am I more likely to develop people who think differently from me, or people who think the same because I'm comfortable with sameness? Unfortunately, in the world of diversity innovations, where law departments and corporations are seeking innovation, working with someone who thinks the same is limiting. You only know this much. That person replicates what you already know. The goal is to expand it. Working with someone who is different will produce better work product, because now you are able to see an issue from a variety of different perspectives. But it also may create discomfort because we're more comfortable around people who we've been around. And so that's part of where the legal community is particularly challenged. And it relates back to this whole notion that we are not forward thinking. We operate in a lag, even throughout the court system. It's in a lag. So innovation and technology takes place, and then we work our way around it. The same is true with respect to identity, right? So Title VII, in a recent court decision about its coverage of members of LGBT community. Similarly, to this day, it still does not cover women of color. Right? We have to go to a sex plus model in order to integrate that. Clearly, women of color are distinctive from white women and from men, and the experience is distinctive, and that is replicated through the numbers we see in law firms. Right? And so I think that we have great opportunity to really re-examine Title VII and its effectiveness in a modern society. So I think that's part of where we're getting challenged, because it too is structural. Most of structures that exist, these interlocking systems within our society, they're undergirded by the legal system, right? So it all starts with laws, which uniquely position us to be the change agents. And so as long as the legal profession is very monolithic and homogeneous, culture seems to reflect the same, because the laws that our culture is predicated on are very homogeneous, because the people who are creating them look the same and think the same. And so I think that there is just a set of intersecting challenges that affect the legal community, and I think also have an effect on society at large.
Absolutely, I agree, Tammy. You know, I think it boils down to this traditional model within the legal field that continues to today, despite the fact that the model was designed without a group of diverse attorneys at the table. I mean, that's where we are today in 2020. There's no denying that. I think you said it perfectly, but I want to focus on a recent example to just let us ponder here. Last month, Lindsay Dates, who is a Black man and partner at Bauries and Thornburg, posted on LinkedIn. His post was addressed to, quote unquote, "Dear in-house lawyers." It reads as follows: "Do you want to know how institutional racism looks in your legal department?" The fictional response from the in-house attorney was as follows: "I know that my current team lacks diversity, but I really can't switch counsel. There's just way too much institutional knowledge at that firm. The firm has represented the company for decades, and maybe even since its inception. I just don't have any power to change." Mr. Dates translated what the fictional in-house attorney said as follows. I would love to switch counsel, but I can't. This group has an unfair advantage over you because they began working on matters during a period when Black lawyers weren't even allowed at the law firms. That also happened to be the same time wherein your grandmother wasn't even allowed to learn how to read during the height of Jim Crow. But stay in touch, because one day, if you're really nice and stay persistent, I may eventually give you some scraps from the table that was built from racism and now has been reinforced by racism. So I think it is incumbent upon our leaders, both within the bar, as well as within the law firms, as well as within local and state government, any of these institutions that have law as their as their bread and butter, to make real changes in the workplaces. Leaders have to develop and implement new programs and policies around anti-racism. We can't continue to follow the traditional model.
Very well said.
Completely agree, and I think my previous comment spoke to some of this in terms of what law schools can attempt to do. One of the things that hems us in is that the legal profession is slow to change in terms of what it values in our space. I recall an anecdote that one of my professors at UF told me about grades and class ranks. The elite schools have mostly gotten rid of that. You don't get grades at Yale or Harvard anymore. You just graduate with pass-fail marks and references from people who you've managed to make mentorship relationships with, and that's a really great model. But when they tried it at UF, the employers were asking students to put their LSAT scores on their resumes. Because they needed something objective and quantifiable in order to cut the pile of applications. At least that's what they said anyway. So I think it's a problem that has to be addressed both programmatically at the law schools in terms of diversifying the student body and diversifying the faculty and bringing leaders up through the system with mentors who will help them form themselves into professionals that look attractive to law firms, but also to law firms and being more open to looking beyond things that they consider, I think, naively to be objective, as Tammy was pointing out. The so-called objective indicators are not always so objective as people think they are. There's an illusion in numbers where we think that if we attach a number to something that it's by nature objective, and that's not always the case. So I think that's a conversation, and maybe this is the beginning of it, but that's a conversation that law firms and law schools have to have together about what's going to be valued on the job market, if not these objective indicators, or if not only these objective indicators. And in addition, that conversation has to happen with the state Supreme Courts who regulate admission to the bar as to what sort of value a multiple choice exam at the end of all this studying has, whether maybe that's the wrong barrier to entry. We've had a movement this year, of course, to move for a diploma privilege in Kentucky as a result of COVID-19, but it started a conversation about why do we even have a bar exam at all? And I'm not sure I'm ready to throw the whole the entire licensing exam out, but it's something that we ought to be thinking about. Is it structured the way that actually makes sense for asking whether somebody can be a professional in a particular field, and that's again something that we have to begin talking about in I guess 3 directions: the schools, the regulators of the bar, and the bar itself. Are these the right metrics for having a profession that can move into the latter half of the 20th century or 21st century?
Thank you so much for that discussion. And this next question might be a good one for you, Professor Bauries, to take with. Moving from the private sector and the legal sector to or the public sector, of course, the current political and social environment has created an atmosphere where cities are considering and are being motivated to consider more equal hiring and contracting practices. Can you discuss the Richmond versus J.A. Crossan case, which is a 1989 Supreme Court case summarized in our handout for today?
Sure. Yeah, and I want to point out to everybody who's just read the summary, if you're not familiar with the Croson case, I know everybody on the panel is, but some of the participants might, or the attendees might not be. That was an extremely fractured opinion. There were 6 different opinions written by the justices in that case, and a good portion of the reasoning in that case is a plurality, not a majority, but there is a majority for the central idea that strict scrutiny applies to benign racial classifications in hiring and in contracting at the state level. There was a decision prior to that upheld those classifications at the federal level. That was then overruled by another fractured opinion called Adirondack Constructors versus Pena, which essentially applies the same rule. And so the rule under Richmond is that programs to increase minority representation in state and now federal contracting are permissible only where the government can identify a history of past racial discrimination in the particular industry, not a pattern of nationwide discrimination, but a more localized pattern of discrimination in the particular industry, in the particular region where the program is going to apply. And that's a really, really high standard. But I want to sort of compare that to the standard that we have for affirmative action programs in education, which is markedly different. The standard for remedying past actual discrimination in education as a basis for affirmative action programs has been rejected by the Supreme Court and has been rejected in favor of a diversity rationale as a matter of the academic freedom of the institution. And so that's interesting that affirmative action programs in hiring in employment, in the world of public employment, have been approved only on a standard that was not approved for the education system to engage in that same sort of benign classification conduct or beneficial classification conduct. And it's always been interesting to me why universities can't justify affirmative action programs based on the obvious and long-standing record of past discrimination in public universities. I mean, it doesn't take more than 5 minutes of research to document a history of discrimination in any public university that exists in the United States of America. So that should be an easy way to defend affirmative action, both in hiring and in student admission in universities. And yet we've reached for this more sort of slippery idea that the university has an academic freedom interest in pursuing a diverse student body, which is a concept that's a very hard concept to define in any sort of specific format that you can prove up in an evidentiary way, and much more difficult to define than a history of past discrimination in that institution or in that industry in the region. It seems like the Richmond standard will be a boon to education, to higher education institutions, that we would have a much easier time defending our hiring and our particularly our hiring, but also our student admission programs based on that standard. Now, what does it do for things like federal and state contracting and set-asides? Well, what that means is that when you have a program like they had in Richmond, which gave a kind of incentive, a financial incentive for general contractors to hire a certain percentage of subcontractors that were minority-owned businesses, that is no longer permitted. It's been shelved into the sort of space that we place for quotas in hiring, which is the most disfavored space you can be in terms of hirings based on classifications. It's been shelved into that spot of industries in the vast majority of regions of the country, simply because the government cannot meet the evidentiary standard that the Supreme Court laid out of documenting a long-standing past history of discrimination in that industry, in that region, or at least the government doesn't do the hard work of making that documentation. My suspicion in the Richmond case was the government just didn't do that hard work and did not actually document a history of discrimination in that industry, even though there probably was one. The government just didn't do the hard work. And so you're placing essentially on government actors the duty of being anthropologists and sociologists and having to engage in difficult research in order to justify programs that seem to be clearly needed based on who gets the contracts today, based on what we can see in terms of how the contracts are actually awarded. So it creates a problem. Now, the other portion of this question is there any way around it? Should the Supreme Court revisit J. Croson versus Richmond? Yes, we should look at this again. We should look at this in conjunction with the affirmative action cases in higher education and try to craft a standard that actually allows for a more nuanced set of decisions going forward. Everything's very formalistic in this area. Either you check the box or you don't, and a more nuanced set of decisions would be better. The problem with that is the theoretical basis for how we do equal protection at the federal level is very tight, is very deeply ingrained now. We had a debate for a long time that ranged through Brown versus Board of Education to the cases that enforced Brown versus Board of Education, then up through Missouri versus Jenkins, and into the cases like the affirmative action cases in the modern era, and extending into the employment context about whether equal protection is an anti-classification protection or whether it is an anti-subordination protection. And the anti-subordination camp was winning for a long time during the Brown versus Board of Education. Brown versus Board of Education is fundamentally about the idea that classification is subordination in that context. Separate but equal is inherently unequal, right? And so the anti-subordination theorists were the ones winning the fight at that time. And then Missouri versus Jenkins in 1983, I think it was, came along and stopped that theory from being preeminent at that time. And since then, the anti-classification theorists have been the ones who've won the day. And the consequence of that is any racial classification, whether it's for a good reason to help people or whether it's for a bad reason to hurt people, is suspect. Whereas under the anti-subordination norm, a racial classification that would have been for the purpose of helping would not have been suspect, whereas a racial classification for the purpose of harming would have been. So that theoretical shift in the theory of equal protection has major implications on doctrine down the road. So I say, yes, we should revisit Croson and Adirond, but we're going to need a theoretical shift on the Supreme Court in order to make that revisiting actually bear any fruit. And that illustrates how theory and practice can go together.
Well, the next question leads right off of that into whether it's in the private sector or the public sector, several companies and firms and cities and all kinds of groups and employers have recently issued statements concerning our current social and political environment that we're living in. How can these companies move from just issuing a statement to actually making substantial change in the communities in which they operate? LaToi, do you want to start us off?
Sure. I saw, giving recent events all around the world. I mean, I think that all companies have been challenged in that regard. And firms likewise, a lot of people are forming allies and are trying to identify ways and manners in which to show their support for those are traditionally underrepresented minority groups. And they have done those by making public statements. But, a lot of times what we're hearing, at least what I'm hearing, at least even within my firm, from people of color or within those respective minority groups it's just we're done talking the talk. We really want people to actually walk the walk. And it means more than just issuing a statement. I think it begins exactly as we began our discussion today. Each organization needs to understand the difference between diversity and inclusion, and understand that while you may have a diverse workforce, you may not have policies and practices in place that make it inclusive of your diverse employees. We also have to recognize that there are going to be baggages or other implicit biases, stereotypes, other types of peer pressure, all the things that we discussed earlier that will impede a culture of inclusion. So those leaders have to recognize those barriers, and identify those head on with respect to and identify ways in which to overcome those challenges. And to be quite frankly, we have to have more of what we're doing today. We have to get comfortable talking about race within our respective organizations. We can all agree, that caring and having a good heart and true intent will help us, but that's not also going to actually effectuate diversity and inclusion. We have to learn that it's equally important to listen and learn and really hear what our diverse colleagues are saying, because in increased communications, it's very, in my opinion, it's very easy to engage in these conversations from the mindset when they're hot on the press, when you have a daily news day. And I don't mean easy in that the conversations are easy, it's just that they're on everyone's mind, at the forefront of everyone's attention. But to me, it's a lot harder to have those conversations after kind of the moment has passed and you truly want to effectuate change. And I want to just kind of talk about kind of increased communications in that space as it relates to my firm. Recently, the firm made a decision to honor Juneteenth as a paid holiday. And Black partners within the firm provided a historical background and written explanation that many, both of color and non-color attorneys, used as their out-of-office response for that day. That engaged, I thought it was a good thing to do. I sent it out. I have a client that I didn't even realize in Asia that had no idea about Juneteenth. Well, they sent it on to their parent things, and it triggered an entire discussion about something that they had no idea about. And it wasn't when anyone was racially charged or emotionally charged about a particular incident. It was true learning, listening, and understanding. And it triggered additional conversations about race relations from both our clients as well as within the firm of those who otherwise didn't know the historical significance of that particular holiday. So I think the ongoing change, the ongoing conversations have to be a continuing part of the group from the leadership. And I think, we have to take action. We're talking about these systematic institutions of racism, how policies and practice can feed into implicit biases, unconscious biases, and otherwise trigger microaggressions and other stereotypes. We have to confront those from the top and be willing to talk about them and honestly listen and share our concerns with one another in a kind of meaningful and respectful manner. But we have to know that the environment and the organization in which we're in supports that type of communication.
Yeah, I agree with what LaToi said, and where she ended with respect to this notion of psychological safety, right? That we're in safe spaces where there can be open communication without fear of retribution, which goes back to where we started with diversity innovations. That is to the benefit of the employer to gain a wide array of diverse perspectives about topics. Before I go further into this particular question, I want to go back to Croson for just a moment. So when we're thinking about the moment of the movement that we're in, and what we're hearing a lot about is the demand for criminal justice reform. There should be a similar demand for civil rights reform, because this is a prime example of where the law is perpetuating systemic economic advantages within a racially stratified society. And so we have to be candid and honest about racial stratification in this country in order for us to move forward with racial reconciliation and healing that is absolutely imperative, right? And so the fact that there are legal theories and legal justifications does not absolve us of an obligation to figure out how we're going to need to be creative and who we need to bring to the table to come up with better equitable solutions in light of our nation's history So we had an entire nation that benefited and was built on an institution of enslavement of other people, right? And so the fact that there is a question about whether a group has been affected within a local setting seems a tad of a stretch. The reality is the entire country, as we can now see, has been affected. And I think what we saw in response to the killing or murder of George Floyd was an international response to what had transpired. And so that's why I keep pushing this envelope of, I think we have to do some real careful examination of the laws and how they may be involved in perpetuating some of the systemic injustices. And I think that is critical, because part of what I evaluate when I'm looking at movements like the current racial justice movement or Black Lives Matter movement is the lexicon that is being used, right? And so two things strike me with respect to this movement. One, with regard to the languages, they're taking language out of academic institutions such as institutional racism, structural racism, right? This is very sophisticated language. Complex theories are undergirding these concepts, and they have made it part of our common culture. And this is important for employers, because what that suggests to me is there is a greater likelihood that employers are going to see an uptick in class actions predicated on race, disparate impact claims, because when you're talking about structural racism, you are digging deep into policies and practices that have inherited implicit or explicit bias, right? And so as much as we were rightfully concerned about re-entering the workplace after COVID-19, I think we have to give equal, if not more, concern to what the new workplace will look like with respect to racial minorities. Because I think the issues we faced have been the same. I think how those issues are being expressed will change, right? And so part of that goes to sort of understanding different eras and dimensions, and I won't go into that because it's not on the table at this point, but I will talk about just briefly, in addition to what LaToi said, our law firm similarly issued a letter, and what we were very committed to was not just those words. So we created task force, we identified initiatives, office-specific initiatives to promote racial equity within the communities we serve, in addition to doing internal examination within our law firm, right? And so it's looking more at what are actionable steps, not towards equality, but towards equity. How do we align? Because again, lawyers are uniquely positioned. We have unique talent. We understand the laws. How do we align ourselves with social service agencies, civic organizations that are experts in this space, and how can we bring value to them in making real and meaningful change? How do we further economic advantages? So one of our programs is providing pro bono work to minority-owned businesses. Helping them to either get created, helping them in the employment law space, wherever they are, IP space for some of them. And so how do we create real economic advantages for organizations above and beyond just a letter? And so I'm very proud of the steps that we have taken in that regard. And I think that's really what is going to drive this process, is a focus on equity.
And our clients, you know, Tammy, they respect our advice. I mean, we advise and counsel in this arena all day, every day. So it's so meaningful to me, or so much more significant, a much more significant impact when you have a law firm as big as a Dinsmore or a Lippert with a unified message to their clients of this is our position and this is what we're going to do. And in turn, people like you, Tammy, advising the general counsels of these Fortune 500 corporations and things of the like about what we're doing and how we're addressing equity as opposed to equality.
Precisely.
And that, there are questions for today. I kind of want to combine a few. Both of you were talking very eloquently about, helping our clients and helping our own firms to grow towards equity. So I was wondering if you could kind of address both how have companies who have implemented things like implicit bias training or other programs, how have those programs helped, or are they truly useful in what we need to do to address our current situation? And then within law firms specifically, it's common knowledge that we have a big issue in retaining employees of color and attorneys of color. So if you could both speak to whether there are structural changes that you think need to be made within the law firm model specifically to help improve that retention.
Well, I definitely think Tammy is the diversity and inclusive training expert, so I'll reply to her on that component. But specifically, some initiatives that I have seen our firm take and others in this space during this area take, and I think will bring about more meaningful, long-lasting, sustainable changes within our group is just the way in which we traditionally handle or assign work and mentor young associates from the partner level. Tammy talked upon this really briefly earlier about how in most traditional law firms, the partners really control the development of a particular associate, either by giving them their assignments, giving them that extra time or mentor, or even giving them the opportunity or that initial introduction to the client that others might not have. So one thing that we've implemented at Littler is something, that was done, our own version of the Mansfield or the Mooney rule. We now require that any partner opening a new matter have to answer a question on their new matter report as to whether or not they've considered a diverse attorney or attorney of color to work on this particular assignment. Going beyond that, anytime there's a case pitch or a proposal to an outside client or a new client, management, if it is not 25% diverse, management rejects it without any review. The team has to be a diverse team for the management committee to even approve the proposal. Beyond that, we're really focusing on our affinity groups. We have affinity groups designed around particular underrepresented minority groups. The one at Littler is the BOLO group for African Americans, which is comes from the West Senegal language to mean together or unity with one another. And so I'm the chair of that group, and we meet monthly with management. It's not just or among ourselves, with the managing directors of our firm, as well as with what we call the officing managing shareholders. Because again, we can have all the policies and practices that we want at the top, policies in place at the top that are led by the managing director. But if they are not developed and actually implemented at the local level by the office managing shareholders, all they are is policies. They don't become practices and they don't change. So we've also implemented discussions with office management shareholders, and I think you have this in your question packet, incentives to the OMS, whether they be financial or whatever, to incentivize them to make sure that they are hiring as well as retaining and training and growing talent among all of the diverse groups within the organization. So I think it starts at leadership, and it requires some really, really concrete objectives. We don't know how these will mesh out. We're going to figure it out. And it takes some data analytics. We go back to that Richmond decision. The key there is they didn't have the evidence. Well, what we found, at least I've been finding as I've looked more into this issue and looking at, how governments respond to these issues, we're not even collecting the metrics and the data to even support these type of positions and things. So not only is it about implementing changes, but it's also tracking, forming data analytics and identifying other metrics to make sure that we're accountable, or that if we're in it to determine whether or not the programs are working and implement new programs. So it's not just throwing out an idea implementing the idea is making sure that there are metrics and objectives in place so that to check the idea and hold those leaders accountable for their efforts in this area.
That was great. And we're involved in very similar types of practices and evaluative processes within Dinsmore, relative to even getting more granular with programs such as Mansfield Rule or modification of the Mansfield Rule to incorporate specific identities. And so we have heavy concentration on women of color. Because we recognize that if we simply say we want diverse identities or racial ethnic minorities, women, LGBT, historically underrepresented groups, and to result in greater opportunities for one of those identities versus some of the others. And so we are very targeted in recognizing where our investment needs to be at this point, and that is in amplifying the voices and the talent of women of color within our firm. Yeah. But in the question about implicit bias, and this goes along with what LaToi just explained and a lot of the structural conversation we have, training does not in and of itself create meaningful change. It takes organizational effectiveness focused on the primary components, which would include the structure, the culture, and then individual agency, right? And so part of what we've been talking about is, in essence, are we conducting equitable audits of our workplace practices, which is what was just described, right? That we're looking at the equity of it, not the equality of it, because that's going to yield very different outcomes. So going deep into those practices and the culture of how things get done, right? So when you're talking about pitches, client pitches, you can have all the great practices, policies, and structures, but how does that really translate from a cultural standpoint? Do you need other safeguards in place, such as a requirement that 25% of the people on the pitch team need to be racial or ethnic minorities or women or LGBTQ, veterans, whatever the particular identity is that you're focused on, or that group. But then there is the individual agency part. And so I think training has to dovetail with all of that. You can't just focus on one or the other. It is a complete system. It's a complete organization. And for enduring a long-term effect, you have to focus on all three together. And I think that's part of the challenge with the legal community, right? We may focus on one, but we've left the structure unaddressed. So we need some contemporaneous work in this space. And that's a lot easier said than done. But so you have to map out the best approach for accomplishing that within an organization that are highly decentralized as they grow. So they're not just in one central location, but how to make it work. And bringing on the OMSs, or office managing partners, as we call them here, because historically there may be a person as a diversity chair, chief equity inclusion officer, who is managing all of this. And our goal is to drive that down within the organization, because that's where you're going to need the accountability and the buy-in, and you can't force those. Right? Part of my assignment is to be able to persuade and to convince and to demonstrate the value of it so that they can own it and follow through and carry it out within their various offices. But going back to the implicit bias, there's several forms of implicit bias training. Some of it depends on where the organization is at. There's awareness training. And that gives us an idea about the social construction of identities, what that means, how that works within an organization, how that works within a culture and society. And then there is the impact training. And that's really where a lot of the work gets done, because that's where we're asking participants in the training to walk away with action items. It's more skills-based training, right? What skills do they need to be effective at managing a multicultural workforce? Because what we know is, with respect to the millennial generation, it is the most diverse generation in the history of our country. And so as they're becoming the predominant group within the workforce, how effective are managers going to be with managing and leading those take skills. So I tend to concentrate in the space of impact training to give leadership skills. It does have an awareness component, but there needs to be about how to have difficult conversations, how to give feedback. That is a challenge, right? That folks don't give feedback out of fear of retribution. So how do we engage in creating conversations, connections, and empathy and vulnerability, all of those things that are necessary to make for an effective workforce in a modern society that is becoming increasingly diverse. So yes, training is important. And of course, right now, we are inundated with it. But I am very candid with organizations I work with. It is only one step. There no longer is training in this space or even with Me Too movement where it's just check off. No, training has to be behavior focused. So it's I think a different time period with the awakening of where we need to start to drive practices and to make meaningful change and sustainable change. So it takes structure, individuals, and the culture in order to make all of this work together.
Yeah, I can't really add much to that. That's really, I 100% agree with that. The only thing that I'll say is that I've been involved in training a lot myself. Used to train teachers before I was a lawyer, and then when I was a lawyer, a lot of my work was going to businesses and training their employees on different things. And of course, I'm a professor now too. And the takeaways that I think align with what Tammy's saying here is that if training is clients oriented, it's likely to be resisted. And if training is innovation and improvement oriented, it's likely to be embraced. And so the challenge for leaders, both in law firms and industry and academia, where is to motivate employees to want to have that training because it is in both their interests and the interests of the organization, and not to say this is a thing you have to do to, as Tammy said, check the box in order to kind of get through the next hoop in your employment progression here. So I just wanted to emphasize that point because I think that's really, really important insight that you just have to, you really as a leader, you have to find a way to get training to be a habit of mind in your organization, and rather than a mandate that has to be complied with and checked off. You get much better results with the former than the latter.
I agree. Absolutely.
And I think, the success of the during the height of the Me Too movement, I think the success of, it being received by employers across all industries at all levels was the fact that it wasn't just about, compliance, from the EEOC task force report, it was about creating a more respectful and civil workforce. In those types of frames, when you look at it from a just human nature and not, we're not looking at, how do you communicate to a Black person? We're looking at how do you communicate to people? We're all people. This is a human issue. And if you start looking at training of, we want our organization to reflect an environment that treats all with respect and civility, it's a lot easier to get buy-in from the top all the way down to the bottom.
Mm-hmm. Absolutely.
Thank you so much. That was an amazing discussion. Before we move on to a little bit more of the nitty-gritty kind of legal parts of discrimination and retaliation claims, I did want to make sure we get to the question about the fact that while we're talking about retention, the unfortunate corollary to that is of course unemployment when an employee is not retained. And so during the coronavirus pandemic, we've all known that rates of unemployment have skyrocketed. And according to the Bureau of Labor Statistics, unemployment rates for minorities were greater in almost every category. Can you shine some light on what factors might have caused this disparity, and could the statistical evidence be used in discrimination litigation?
Well, I can't speak to the causes, but to the doctrinal implications, the causes that's an empirical question. And I think that needs to be researched thoroughly. And the doctrinal question is going to depend on why employees are being let go, and how the decisions are being made at each employer, each workplace. These sort of general trends, unfortunately, are not really probative for individual employers' decision making. And so when it comes to the courts, it's going to matter whether a particular workplace fits that trend, and if they have a reason for that trend being fit. There could be legitimate reasons. There could be a last hired, first fired kind of policy, and it could just be skewed in that way. But it'll have to be tested employer by employer. The societal information is certainly helpful in helping us identify a problem, but it's got to be litigated as to the individual employer. So these Bureau of Labor Statistics findings are useful to tell us that there's a problem, and that certainly is a problem, but we've got to investigate it individually at each workplace.
Mm-hmm. And I think it also, there's that X factor of the particular industry, so if we're looking at specific industries and we can see a trend in specific industries, it might be useful for discrimination mitigation going forward. But, I think, without the data, it's just LaToi Mayo, educated guest 101 is, there are just, in our society, there are particular industries in which are dominated by people of color. It's no different than my grandmother's times, pre-1964 Civil Rights Act. When my grandmother, you look across my family's work base during that time, they were all domestic workers. We had teachers after the 64 acts and things, and then that was just particular the industries that we saw a lot. I saw a lot of my family African Americans in, in this type of time, when people are not having, don't have that extra money to work those particular service related industries that I think people saw a minority in even today, despite the changes in the law. So I don't have much evidence in support of my guess. It's just that I just have my own personal experience and my assumption based upon that.
Yeah, I echo those sentiments of both Professor Scott and LaToi with respect to the question. I will share observations that I thought was interesting about the coronavirus related to furloughs, terminations, and generally, is that people of color, African Americans, Hispanics in particular, were disproportionately affected in a negative way relative to health disparities. Yet many of these individuals were in essential employee positions for which they receive low wages and greater exposure to the virus. And so coupled with that is this other bit of the cluster, is that when furloughs needed to take place, once again, we see this negative disproportionate number of people of color, very similar to the same effect with regard to the economic downturn back in 2008. And so it is interesting whether or not there is proof there that this is related to race is one question, but then there's always that theory, I think, is it res ipsa loquitur, the thing speaks for itself. Unfortunately, it doesn't exist in employment law, but certainly there is something intriguing in this space that this group is disadvantaged in these spaces. And so there has to be a plausible explanation as to why that is recurring, not just again with the coronavirus furloughs and terminations, but also again with the economic downturn in 2008, and probably a series of other patterns exist to demonstrate that the same facts.
Yeah, particularly and that's really important what Tammy just said. Particularly, it's really fishy that people of color are more likely to be in essential worker positions, which did not experience the kind of mass furloughs that non-essential worker positions did, and yet experience greater likelihood of furloughs and layoffs and terminations. That's fishy. Those two things shouldn't both be true at the same time, and so we should look more deeply at the data individually.
And speaking of in employment decisions, and yet not necessarily having a legal basis to vindicate that feeling, I would be remiss if we didn't make sure that we focus on employment discrimination claims before our time is up. So I wanted to get to the fact that a 2019 article noted that out of all of the workers alleging discrimination, whether it be race or age or gender or just what have you, race claims are among the most commonly filed, but have the lowest rate of success, with I think just about 15% receiving some form of relief. Why is it, do you think, that race claims have the lowest rate of success, particularly given that they are analyzed under the same legal framework as other protected classes? LaToi, do we want to start with you?
Yeah, I'll take that on. That question I've pondered a lot because, you know, exactly from the same point, you know, position you stated, Robin, that, you know, it is the same legal framework to prove whether or not you're pursuing a race discrimination as opposed to a sex discrimination claim under the law. You know, you either have direct evidence or you have circumstantial evidence, and you operate under the kind of the McDonnell Douglas type of bird shifting model. Yet and still, I was surprised, you know, because about the statistics when I read that article and with this question. Why is it that race claims have the lowest rate of success? I think there's a myriad of factors. I think it historically goes just based on just the kind of value of others, of minority races within America, historically. Those, you know, we are, you know, 60 years removed from 1964 Civil Rights Act. We have individuals who were directly impacted at play, still existing today, still making our juries, still making decisions as leaders within organizations, still making policies and practices within our governments and at both the local, state level. And I think whereas conduct can be regulated through laws, I think it takes a lot more societal advances, education talks like this to change mindsets. And I just don't believe that as a society, we are at a point where there is a majority acknowledgement that race discrimination exists, or more importantly, that systematic racism exists. So until we overcome, to me, that perception or view as a society here in America, we're going to have disparate numbers with respect to discrimination classes based on the individual protected characterization. I mean, there was a point in time where, you know, society viewed women and African American as inferior to Caucasian males. And while I don't think that is the current trend among all, that notion, that theory, that mindset of thinking has not completely dissipated here in America. This is just Truth 101 from LaToi Mayo.
Yeah, I don't think that mindset has disappeared. I think, and this is kind of a flippant way to say it, but I'm trying to make a metaphor here, I guess, that people have sort of learned to kind of, for lack of a better word, behave themselves publicly in their kind of public-facing activity. And so race discrimination is not as immediately evident, even though it may be in the minds of people making decisions. And so race discrimination claims tend to take the form of disparate impact claims rather than disparate treatment claims. And disparate impact claims are much harder to prove in terms of marshaling the evidence and overcoming a defense that's much more accessible to employers than the sort of "I didn't do it" defense that you usually hear in a disparate treatment claim. So I think that's probably part of the explanation. I'm speculating here. This is like several of the questions on this sheet. It's an empirical question to figure out why 15% of the cases are successful. There are a number of plausible explanations for that, but empirical research on the law is fraught. And one of the reasons fraud is a lot of it's done by political scientists who like to take everything and numerize it. And law is just not numerizable in a lot of in a lot of ways. A legal decision doesn't involve just a winner and a loser. It involves a number of small victories along the way. Why did you prevail on the motion to dismiss? What was the decision on the political question doctrine? Why did you decide to admit that evidence, right? Each one of those decisions drives the outcome in some way. But generally, the social science approach is just to figure out who won and who lost and then track the decision empirically on that ground. So we have to, as legally trained folks, we have to get more involved with studying legal cases, either as advisors or partners to social scientists to help them understand that there are inflection points along the line in every case. And it could be the charging document, it could be legal representation availability, it could be the access to the justice system in terms of door closing doctrines like the Twombly-Iqbal pleading doctrines or standing doctrine. All of those things could be doing work in these cases. But we don't know because we don't break those things out when we study law cases. We just break out who wins and who loses. So we could really learn a lot, particularly when you have a disparity like this, when you have cases that are based on gender or on religion or on national origin succeeding at higher rates than cases based on race. Something seems to be going on there. But we've got to break down the case and figure out which of the inflection points are seeming to make a difference there. And if we can eliminate all of those, then what's left is probably that there's a lot of systemic racism built in the system, and it's probably doing the work there if it's not those legal inflection points. So by process of elimination, by logistic regression or whatever we want to call it, we can arrive at a conclusion that maybe will help convince everybody that this is more of a problem than the general wisdom seems to think it is.
And speaking of those legal inflection points, one thing that I've been thinking a lot about while preparing for their conversation today is the role that precedent plays. And I think, Tammy, you were picking up on very similar ideas at the beginning of our conversation. And when it comes to things, especially like hostile work environment or harassment claims, if you look at kind of decades old cases, some of the standards that they set forth are a little shocking. Environment so heavily polluted with discrimination as to destroy completely the emotional and psychological stability of minority group workers. And, it seems the question I want to pose is, how does our legal system, based on precedent and stare decisis, hinder progress in the law's ability to address racial discrimination in the workplace? If a decades old decision says, doing X, Y, and Z is an actionable harassment, but today in 2020, we most certainly would not believe that doing X, Y, and Z is acceptable in the workplace. Can our legal framework as it currently stands be effective in helping our society stamp out racial discrimination in the workplace? Tammy, do we want to start off with you? Because I know you were talking about Title VII and how it might need to be reformed.
Yeah, so the fact that I was talking about that suggests that I have some concerns with following precedent from a law that was developed in 1964 and based on the history of this nation and its relationship to race, where many of the lawmakers, and I think LaToi picked up on this earlier, don't look like the demographic group that is most affected by the law. So I think we need to re-examine and revisit some of the legal frameworks, now gathering input from social scientists, also from practitioners, academics, but people who have diverse perspectives in terms of their professional frameworks, but more importantly from diverse populations, the individuals who are impacted by them, because they will know best whether or not something that is within the framework is really valid. Because one of the things we have to recognize is, as high as the numbers may be for the number of reported race claims, most claims of race discrimination are never heard of. People of color have coping strategies built in. So you're getting about 0.01% of the number of actual claims that be made, right? A very small fraction. So we are socialized very early about how to navigate through bias systems and structures. There is a built-in level of tolerance, right? And so I think what is more likely to happen before there's a change in the law is that employers will make changes. Because for employers, discrimination is now harmful because the diversity innovation only works when you're able to recruit and to retain certain populations of individuals, demographics that may not have otherwise been freely brought on board. But now that's where a lot of your future growth is going to be concentrated. So there's a business reason for it. And so I think that's going to drive change more than the law, which is really unfortunate because the legal profession, again, ought to be the members of society leading on issues of racial reconciliation and healing and harmony and justice. But I think we take our steps from corporations and businesses versus legal profession, a noble profession taking the lead on and really getting out there and saying, oh, this is what we ought to be doing. So I do think that we have challenges because we're looking at precedent on occasion. I think we all know realistically through common law that judges will make decisions that do not follow precedent. And the circumstances under which that is happening, I think, could be further explored. I just don't think it happens a lot in this instance because there are social neuroscientific reasons behind it and how we see race, which is what I think LaToi just talked about. And so that may be reflected in our decision making for sure.
There are also structural impediments to the law forming a solution here. Structural impediments in the law itself. I just got done teaching Svierkiewicz versus Surema to my students on the teaching pleading and civil procedure. And that's 2002 decision that basically held that you don't have to plead the McDonnell-Douglas factors as a standard of pleading under Rule 8. After Twombly and Iqbal, you kind of do, but before Twombly and Iqbal, you didn't. And so one of the things I explained there was that the Second Circuit had the rule that you had to plead the McDonnell-Douglas factors, and several other circuits didn't have that rule. And so what happened here? And one of the explanations for that is defense side interests are generally much better funded than plaintiff side interests. And they can hire a larger team of very gifted lawyers and move the law in their direction over time. Even if that direction seems to be contrary to the way the law was originally intended, good lawyering can achieve that over time. And it will achieve that over time. And so to a certain extent, at least on the defense side of the employment bar, at least the employment discrimination bar, there's a sort of conflict between the ethical obligation to our clients and the desire to improve the law in the direction of racial justice if our clients are the ones who are accused of committing racial injustices, right? And so that's a difficult knot to untie. And so I tend to agree with Tammy that the solution is probably not going to be found in the legal standard ultimately. Whatever legal standard we lay down, defense side interests in the employment discrimination context will, as an ethical obligation, move the law in their client's direction over time. Eventually that will be sometimes corrected by Supreme Court decision making, and sometimes it won't. Sometimes you'll have a Fifth Circuit case that says something crazy and shocking like this that's still on the books, right? And you won't have that corrected over time. And so the solution is to be found more in corporate culture and law firm culture, improving in the direction of justice rather than forcing it in that direction. Not that we shouldn't try to have a legal system, a set of legal standards that are more just. We shouldn't just place all of our trust in that system to fix the problem. It's just not equipped to do that. Structurally, the interest in serving your client is sort of opposed to that interest by virtue of diligent representation.
And I think you guys had a great point, because we saw that with the Me Too movement. You know, the 1986 decision recognizing sexual harassment, you know, and having that standard out there from the Supreme Court didn't change, you know, but employers, society's approach to sexual harassment that was brought about by the Me Too movement did change. So you just had industries across the board at all levels just taking a zero tolerance, irrespective of the standard. And when we went when we were training, or me, or training on that, or, you know, our workforce and our clients in that area, you know, once again, we talked about respect and civility. We talked about having policies and anti-discrimination practices that went beyond the law. You know, we don't want a culture that's legally compliant. We want a culture that is respectful and civil and encourages diversity and inclusiveness among our entire group of workers. And I think with that line, I think we saw a real shift, exactly as Professor Bauries and Tammy noted. It came from the employers, it came from society, it came from the companies, irrespective of any change in the law.
And LaToi, I'll piggyback on that for a moment, because we actually saw that during this movement, right? So there's always the brand reputation of a company. So it doesn't wish to be involved in some type of widespread, pervasive race discrimination issue for fear that it will damage the brand. And so we saw companies, quite frankly, standing in solidarity with the movement. That's why you saw the letters issued to demonstrate that we support this cause. But then we also saw some brands come out and they changed some of their historical iconic images out of recognition that there was potential for damage. So I think it supports the position that the three of us have identified in terms of a lot of this change will be driven by business reasons versus because of there's some monumental change in the law.
And the only thing that I would say on top of that is we just have to be mindful that argument does have some force, but it can't be allowed to have too much force. Because that was the argument that originally was made against Title VII, right? Is that let's just let economics handle it, right? Businesses that discriminate will go out of business, right? And
you can have a multifaceted approach.
Yeah, exactly, right? So it's got to be that and. It's got to be yes and with that, right? The law can't do it all, but the law can certainly do something.
Well, we do have one question. We're just about out of time. That was a wonderful discussion. We have one question from the audience, which I think would be a great one for Professor Bauries to take, which is how can we make the judiciary understand how these issues impact their decision-making process?
How can we make...
I know it's a lot to throw at you right as we're ending.
You know, I actually think many judges think about this a lot. And you know, federal judges in particular, I've known a number of them, and they're extremely thoughtful people, and it really doesn't depend on who appointed them, how thoughtful they are about these issues, as one might assume, you know, and so I'm not sure that they have to be convinced. It's just that they are constrained by their role too. They have to credit the argument that they think is best made and most forcefully made, and they're sort of constrained by that, which I really just think that kind of bolsters the point that the law can't do it all. Judges are hemmed in by their role, attorneys are hemmed in by their role. All have ethical and professional obligations to do things for the people who have entrusted us with the power that they've been entrusted us with, and so some of the solution has to be found outside the legal system. Now, one thing that could be done is more interaction between judges and the bar on individual bases, not just in the court system, but on an individual basis, and between judges and academia. And I think, you know, you see a lot of that happening, but a lot of times it's the judges who take the initiative in that process. And I think the bar and academia has to take more of an initiative in involving itself with judges. And again, it's not a sort of mandatory idea. We're going to train all the judges, right? Because they'll just resist it. But the idea that we come into contact with them more and that we have more of these conversations like this. I hope there are a couple of judges in the attendees group, because that's the kind of thing that needs to happen, is these sorts of conversations that are not directive or mandatory, but that are productive and constructive in the sense that we're all contributing something from our own experience. That can assist people over time.
Well,
I don't have to elaborate on this stuff.
Exactly. I want to give Tammy and LaToi, if you the opportunity to say anything that you think we missed. I know we have to wrap it up, but I don't want to cut anybody off.
I think it's been a great discussion. Thank you for having me.
It has been an absolutely fantastic discussion. I know I have learned so much from participating in this, and I hope our participants did as well. Thank you so much to you three for such a great discussion today, and I hope everyone has a great day.
It's been a pleasure and an honor.
Thank you.
Bye.
Bye.